which I mentioned this CFD last week online, but thereafter the bench has changed. So now the situation is that there is an order by which interim order is available only till 23rd of May. Now, says that
interim order by us.
Yes, by
how could it be? Acha, oh, that matter.
Says that matter. Now we have received the notice from SESTAT that since the roster has changed, so now it will take about 13th of June. So that is why we have filed a modification for extension, and I am such a fix that the bench has changed. But then the notice says that the roster which is taking up the regular matters, that will only hear other matters as well.
Let us also think over it, whether it is tied up matter or what.
Yes, I think because this situation we had faced earlier, sometimes from 2009. So what had happened was the same situation. So we mentioned it was the present bench then, and the bench what it did, it took up the matter, extended the order, but kept the petition pending for disposal by the regular bench.
We have disposed of this matter.
Yes, yes.
Restoration proposal we have to place no protection request from the system to place no
You give your slip, we'll take a call on it.
But
Yeah.
may I mention item number 24 from today's list? I am withdrawing this list. The petitioner will already pursue the alternate remedy.
24.
24.
Okay.
WKD number 3007 of 2019. The instructions are also.
This was against?
This was against an order in appeal matters from the Commissioner of Finance, Central Excise. The main ground was that cross examination was not allowed to us, so we had challenged violation of principles of natural justice. But the clients are willing to pursue the alternate remedy. To pursue the alternate remedy, before the SESTAT, we are withdrawing.
Okay. Item 20. Item 24. On counsel for the petitioner, Mr. Rahul Amba seeks permission to withdraw this writ application on instruction. The written instruction conveyed to learned counsel through mail has also been produced from your client, which may be kept on record. Stop. Who is the other side? Okay. No objection. The writ petition was preferred for the following reliefs. Para 1, A, B, C, D. Stop. Then counsel for the appellant submits that the petitioner submits that the petitioner is interested in pursuing the alternative remedy of appeal before learned SESTAT. Stop. Then counsel for the respondent does not have any objection, Mr. P.S. Pati. In that view of the matter, the petition is dismissed as withdrawn with liberty to the petitioner to pursue his alternative remedy as is available in law.
There was a joint request by the appellant and the respondent. The hearing matter, the last matter of the court.
Okay, I was also not inclined to get into hearing matter. A joint request has been made by learned counsel for the appellant, Mr. Sumit Garodia, and Mr. Rahul Lamba for the department, revenue, for adjournment. Stop. They pray that the matter may come up after summer vacation of 2022. As prayed for, list the case after summer vacation 2022.
There are many not seen. I am observing to ask some law. So what I am working
हिंदी
as
में बोलिए, हिंदी में आराम
I am
से.
working as a science teacher in Navodaya Vidyalaya, Gandhra. One of my review, civil review 36 of 2019, surviving defects. It's my humble submission lordship each possible timely ignored because of I have not a line of legal expert lordship. So that may be decided on very lordship. Any date may be placed in the month of June.
सिविल रिव्यू किनके आदेश से अराइज कर रहा है? कौन जज साहब लोग थे बेंच में?
Honorable Justice T.N. Patel, acting Chief Justice.
और
And Honorable Justice Mohammed Mulki.
ओके, स्लिप दीजिए, फिर आपका केस लिस्ट पे आएगा. जिस दिन लिस्ट पे आएगा उस दिन आपको मौजूद रहना होगा.
So my submission is that any date may be placed. So I have an apprehension to
हम ही लोग के बेंच में आएगा. ऑलरेडी हम लोग टाइम दिए हैं. ये तो टाइम ऑफिस को रिपोर्ट करने बोली. इसमें बहुत सारे डिफेक्ट हैं, 28 डिफेक्ट हैं, वो सारे इग्नोर होने लायक नहीं हैं. 28 नहीं, मतलब 12 से 28. 1 2 3 4 5 6 7 8 9 10 11 12 डिफेक्ट हैं. तो ये अगली बार जब भी लिस्ट में आएगा कोई डेट दे दीजिए ऑफिस से रिपोर्ट लेकर के, और फिर उस दिन आप मौजूद रहिए. नहीं तो पहले लिस्ट में आएगा तभी इग्नोर करना, और सब इग्नोर करने लायक होगा तभी इग्नोर करेंगे. ठीक है.
So, scale number 33 to 47.
Yes.
This is the scale 33 to 45 those matters in which section 108 interpretation.
108 and verses 107.
GST has not yet filed. GST has not filed the counter as of now, and that is why I thought I'll call my senior, and I circulated a letter with
Mr. Pati is for.
Amit Kumar is appearing.
Okay.
He is yet to receive the instruction. I had a word with him. He will not receive the instruction, so he will not.
Why you are taking so much of time? This is a issue. This is an issue which almost on regular daily basis the authorities would be facing, whether to entertain a revision under 108 or relegate them to appeal on a SSC information.
Yes.
How much time do you require?
Amit Kumar is appearing.
Twice time has been granted,
Yes.
perhaps. Despite twice time granted, request is from the other side.
No, which he circulated the letter.
A request for adjournment has been made by learned counsel for the petitioners, for which an email has also been circulated. Stop. Respondent CGST were asked to file counter affidavit.
There is GST.
Sorry, GSTN. By CGST. CGST. GSTN is a network. File counter affidavit, perhaps in lead matter 1 or 2.
Yes, yes. WPT 28 of 2021.
28 of 2021, which has not been filed despite twice adjournments.
Yes.
Stop. Then counsel for the respondent, CGST, has also prayed for time. Stop. By way of last indulgence, 4 weeks more time is allowed to the CGST to file counter affidavit.
I can fix a date in this matter because during pendency, now there's a threat of recovery is there. So we have filed a earlier petition for that also. Madam, you can fix a date any on a virtual day, Mr. Or if it is physical, whatever is convenient.
22nd June.
Well, sir.
Let it be on a physical day so that Mr. Kurmi has to.
Yes, yes.
Because this an interesting and a.
Can I pay for 27th June?
27th would be okay.
27th June.
27 June. Petitioner may in the meantime also file reply to the counter affidavit of CGST if so advised.
That's that is also for 46 and 47. Simplicity advantage.
Before the list is prepared, why don't you send the adjournment list so that the matter may not come up every day? This is happening.
The list came yesterday this afternoon.
Now a demand may come from the bar that before preparing the list, please circulate the draft. Which items?
This 46 and 47.
46 and 47. What was this about?
This is again a challenge to the assessment order. Looks like taking aid of NKS.
Okay. So why is the request for adjournment?
So Mr. Kurmi was leading this matter.
After vacation,
Yes.
46 and 47 pleadings
6
are
or 2 minutes.
no, not in first week. Pleadings are complete. Top Hour Learned Counsel for the petitioner, Mr. Nitin Kumar Pusari, prays for an adjournment as Learned Counsel from outstation, Mr. Karthik Kurmi, would address the court. As prayed for, this is the case in the week of 20th June.
It's 20 to 22nd, but I was not here. Family something there.
23rd?
23rd is
23rd June.
23rd.
Our no further adjournment should be sought.
Much.
Any compilation, etc., you have sent?
This, everything is there.
Okay.
They've already furnished.
Yes.
Serial number 60 and 23 matters for adjournment to the matters. Both the matters are we have to seek discussion of the client.
Okay, right. 16 and 23 is WPT.
The rise on 2019.
16 pleadings are complete.
In 16 ballot, ladies are complete ballot. We have to take discussion that matter as you listed on a present ballot. So what is the late status ballot? We have to take discussion from the client.
Learned counsel for the you have not gone before SESTAT and come after the appellate order.
Beyond limitation of.
And counsel for the petitioner, Mr. Manjit Kushwaha, prays for an adjournment to seek instructions. Since the matter has come up on the list after quite some time. As prayed for, let the matter be listed after summer vacation. Name of your name is appearing.
For CGS.
Mr. P.S. Pati for CG. And 23, what is that?
23 ballot on earlier ballot, we were required to sign the highest copy of the assessment order ballot. Could not be filed. The client was applied for the high copy of the order ballot.
Okay, that matter. And counsel for the petitioner submits that the certified copy of the order dated 22nd October 2018 has not yet been furnished,
Yes, madam.
despite application being made. In order to bring it on record in terms of the order dated 25th June 2020. Mr. Who is appearing? Mr. Pati, you are appearing. So, Mr. Name of who is the counsel? No, Mr. Ajit Kumar and Ratnesh Kumar. Ratnesh Kumar is no longer.
I think this is DTCI. DTCI matter.
Very well. No, but for the state, then the name of the Advocate General's office should appear. Let the name of Mr. Dubey. You will be appearing in this matter. Since the let the name of learned AG उसके बाद लिखिए. The matter is adjourned for 4 weeks. Mr. Pati, you tell whose order is it? Certified, which you are seeking certified copy?
Yes, madam.
No, not the DDGI. The assessment order should be of some other authority. State tax.
State tax.
Mr.
We also
Pati,
confirm, madam, if you cannot write it in the order.
I said simple likhiye, and counsel for the petitioner has prayed for further adjournment. As the certified copy of the order dated so and so has not yet been furnished by the client. Stop. You see why, Mr. Pati, why, whether if they have applied it or not. As prayed for, list the case after 4 weeks. Let the name of Mr. AG2, learned AG2 appear in the cause list in place of Mr. Ajit Kumar, learned erstwhile AG. ऐसा करिएगा ना, वेकेशन के बाद से जो मैटर अगले सप्ताह में लिस्ट होगा उसका एक ड्राफ्ट लिस्ट पहले एक सप्ताह पहले नोटिस पे डाल देंगे, so that councils may be ready with the instructions in those matters. जैसे 6 जून को खुलेगा ना, तो 6 जून को 13 जून वाले सप्ताह में जो केस चढ़ेगा नया या पुराना, उसका एक लिस्ट टेंटेटिव 25-30 केस जो सडनली चढ़ने वाला है. Then counsel for respondent has also sought an adjournment perhaps, or you have sought it.
Petitioner may have sought, madam.
Achha, you were granted time for some instruction.
I have taken instruction, the identification was not over by that time when it was not taken.
Then counsel for the petitioner, Mr. Mahendra Kumar Chaudhary, prays for time to seek instruction as the matter has come up after some time. Then counsel for the respondent, CGST,
Yes, madam.
service tax, has got the instructions in view of the previous order dated so and so, 25th February 2021. However, in view of the prayer made by learned counsel for petitioner, list the case after 4 weeks. Yeah, after summer vacation.
Serial number 25 from Delhi Hospital, this was not released.
By Mr. Piyush. इसमें क्यों टाइम ले रहे हैं आप?
In this possible case to come before a minute from outside, due to short notice, you will be done.
ये पेनल्टी वाला है ना? वो 1995-96 एडवांस टैक्स एडजस्टमेंट.
Yes, pay not to. The case that we have given you from
As prayed for the learned counsel for the petitioner with consent of the other side, matter is passed over for the day. Mr. Deepak Kumar Dubey.
with your permission, may I mention the criminal appeal in the 14 of 2015.
See, we are not in criminal appellate jurisdiction. If it is tied up with me, then please seek the consent of brother judge before mentioning it before me. You should make a request. अभी उनको request करिए.
It has been tied up to you.
Some.
leave of residents.
Why don't you wait for the, after the summer vacation to make this?
Lordship, after, I mean, IBA has been filed for treatment of the life of the petition.
Criminal suspension refused and provisional treatment and नहीं करेगा this week नहीं take up करेंगे. Who is the other honorable judge?
Honorable Mr. Justice, not the name.
You give the slip, Courtmaster will see to it.
On daily basis, serial number 28 and 29, I'm paying for adjournment. I also made adjournment in this very worship.
Why?
Worship, as I think 3,000 slightly towards the not available.
Now this is ready
Yes, yes.
and no promotions are being.
No,
Then any suggested date from both consent of all the sides?
why do we go to law? I think it's starting.
On the ground of the senior counsel, Mr. Rajiv Srivastav, for which appellant? Respondent in which appeal? Respondent in both the appeals. क्या लिखे?
On the ground of senior counsel, Mr. Rajiv Srivastava.
Rajiv Srivastava. The matter is adjourned with consent of the parties. The matter is adjourned to 16th of June. However, no further adjournment should be sought.
Yes, because we have mentioned in serial number 48, because yesterday I filed the 100 year in time. And the principal officer is very matter many days for those issues.
So this respondent number 1 has filed any affidavit?
No, we have not accepted. It's not accepted.
There is an interim order in your favor.
Yes. Still today.
You want an adjournment for an outstation counsel too?
Yes.
Respondent, service on respondent number 1 is complete.
Yes, sir. Affidavit has been filed. It has been sent through email also, from the side of it.
Respondent number 1 has not yet entered appearance despite service of notice and indulgence granted on the previous date. Previous 2 dates. Stop. Rejoinder affidavit has been filed by the petitioner to the counter affidavit of respondent. Rejoinder affidavit has been filed to the counter affidavit of respondent number 2 on 7th.
To the IE application for amendment. Earlier they had filed main counter, that was inscribed by the application. And on the 30th of April, they have filed the reply to our amendment application, for which we have filed the rejoinder.
They have filed an amendment.
No, we have filed it.
Then rejoinder is to what?
Rejoinder to the reply of the amendment.
Reply to IA and then rejoinder to
Yes.
that reply. You can't file a rejoinder to a reply without seeking leave.
So they have taken some point because
You should have sought leave of the court.
that is
Adding to rejoinder and sir rejoinder is not permissible without leave of the court.
yeah.
This matter had gone to some other bench.
Yes, sir. It was listed on 22nd of.
Oh, acha. I was sitting singly.
Yes, that day.
Our learned counsel for the rejoinder to reply to IA has been filed on 7th May 2022. Learned counsel for the petitioner prays that the matter may come up on any day since an outstation counsel has to address this court. through VC or virtual or physical day? This is the case on 8th June 2022. Interim order dated so and so. 23rd February 2022 shall continue till the next day.
तो जो आगरा था 13 जून का डेट इस गया था
इसे बता दीजिए.
From the daily code list, under the heading for orders in defect. Item number 1, WPT number 4774 of 2017, Mr. Ashok Kumar Yadav for the petitioner, Mr. Om Prakash Tiwari for the other one.
On 3 and 17, there was a mention that the petitioner is self-applying the power of attorney. They mentioned in Bharat 6 in supplementary application.
Petitioner is a company. Who has filed the wakalatnama?
They mentioned the petitioner company that take the power of attorney. The lead petitioner should have been filed through Mr. Vivek Tiwari.
Through its authorized signatory.
Yes,
Have you enclosed the authorization letter?
yes, last week.
Supplementary affidavit. Supplementary affidavit dated
3/10/2017.
17. Okay. So same authorized signatory is there. Supported by the authorization enclosed to the supplementary affidavit in favor of the Sri Vivek Tiwari, Head Finance and Accounts. Fresh wakalatnama has been filed. Stop. Where is the original power of attorney? Wakalatnama may be accepted. Matter be listed under appropriate heading. Surviving defect is ignored. Matter be listed under.
Item number 2, civil review number 120 of 2019, Mr. Abhishek Kumar for the petitioner. The roll number.
Substantial defects have been removed because two defects which are remaining because defect number 12. May agree that defect number 12 is actually
Deficit code fee?
deficit code fee.
What is defect number?
Defect number 12 is not black text. There's a notice not that states that a petitioner must file the entire document which they wish to rely on.
An entire document of the writ petition or this tax appeal?
That is the only document which we are relying upon the petition and the order. That is the only document which we are relying upon this matter.
Okay, then take care, notice. मिलेगा टैक्स अपील का फाइल है ऑर्डर जजमेंट है वेरी गुड since the connected record of tax appeal number 15 of 2015 is already there along with the present civil review petition. Defect number 12 is ignored. The Appellant Counsel for the petitioner undertakes to remove the only surviving defect by filing deficit court fee of rupees 230 within this week. Matter be listed after summer vacation. You have, if you want to take objection to this 619 days delay, you can file your reply. Mr. Rahul Lamba may in the meantime, when counsel for the department may in the meantime file reply to the prayer for condonation of delay.
Item number 3, WPS number 2994 of 2019.
Sir, it is good that if you granted whether the things are wrong, that's okay. And
1 week after opening of summer vacation, as prayed for, is allowed to remove the following surviving defects of which to place the file. Let the name of ASJI Mr. Prashant Pallav appear in the cause list in place of so and so.
Item 4, WPS number 1269 of 2022, Ms. Srishti Sinha for the meeting.
there is no objection. It is only the higher level it is stated that it is an article 256 and 257, whereas it should have been only 256. The provision of law, and the objection raised is that the provision of law is to be only 226 and what is mentioned in the IA is 226 and 227.
Provision of law may be verified with IA number 3035 of 22.
That is only and 227 is to be,
You have come from outstation. Who is the local council? Should introduce Leonard Senior. I just missed the name.
my name is A.K. Bera.
Okay. So, what is the matter about?
The matter is about my notes may kindly permit me to give both my dates at the beginning so that I take my notes to the improvement a little later. So that the crux of the issue before my notes will become clear.
This is arising from SCAT.
Yes,
Because it was a defective matter, since it was listed under the defect heading, we generally do not go through the files of defective matter. So, unless there is an immediate urgency, you can address us on any day which you choose. We can keep it on orders, or is there any IA? We can keep it under admission on any other day. Is there any immediate?
Immediate urgency matters taking up any branch university. There is no immediate urgency.
So, whichever date you suggest, we can keep it. But this could be after vacation. All the respondents are present. Who are the respondents? NHAI. You? Okay. You are for Union of India. No private respondents.
No, there is no private.
So it's a case of reversion.
This is a case of reverse.
Mr. Bera, have you come to Ranchi earlier?
Yes, I have come to Ranchi several Since the inception in 2000 also I had multiple matters and Justice B. Gupta was the Justice here.
So, if I am not mistaken, it's a digression from the main thing. Perhaps were you the counsel in some Indian Forest Service matter?
Indian Forest Service matter, that was the case I was talking about. Any case matters.
Because
In the year 2000,
you have-
the state was bifurcated.
You have grown a bit bald from that time, and therefore
Yes,
I'm sorry I couldn't recognize you.
Yes, matters.
I was appearing for some of the parties in that matter.
Yes, matters. Yes,
Pleasure to see you again.
matters.
So, as you suggest, we can keep it on any date.
But since I would submit, since all the parties are here, if it is possible, if I not things straight, I lost my issue a formal notice to NHI. So that on the next step, maybe this can be done finally at decided.
The pleadings before the learned CAT are
Yes,
on record.
entire pleadings matters we have filed as it is. The way, the outcome and the rejoinder, all the three things have been filed, and even the miscellaneous application which was filed before the tribunal for taking certain additional documents and record, that has also been filed.
This petitioner is an officer of the NHAI,
Yes, matters.
reverted after a disciplinary proceeding.
No matters. It is matters on the ground that there was a case before the Supreme Court matters. That the degree certificate obtained from the Rajasthan University is not a valid degree now, they say. But whereas my promotion is based upon the recruitment rules of the NHAI, for promotion category, degree certificate is not required. Diploma is good enough. But the 11th tribunal matters has been decided purely by another case matters, which is I would be able to distinguish it before my laws, and I will be able to point out that the point which I am placing before my laws about the interpretation of the recruitment rule, that was not even placed in that case. But the 11th tribunal said that since there is already a precedent, we will not go into any other aspect.
What is the IA about?
But the idea is about taking certain additional documents and record. Because subsequent to my case, the NHI itself has clarified by issuing a circular that the educational qualification prescribed for direct recruits and deputations is not applicable to the promotions. And
That is
secondly,
after the impugned judgment.
after the impugned. And what was implicit in the recruitment rule has been made explicit by virtue of this memorandum. And secondly, matters I have put down all the APAs of mine, starting from the time when I was a technical assistant, when I was promoted even as manager technical, as well as a deputy general manager. Well, I have been promoted by 2 stages. Now they are reverting me by 6 stages. 24 years of service, and the person is deemed to have been continuing in the service as if he was appointed as a first employee today. Very hard case, but my that issue lies in a very narrow compass.
Which is on the technical side or on the administrative side? Officer?
It is a technical side.
So you respond to both the writ petition and the IA for additional document. And we can keep some time for you to file reply if necessary. We can keep. No, we do not know.
A question of the interpretation of the recruitment rule.
Whatever.
Yes, if my learned friend says, I don't think whatever the NHAI is filed before the tribunal, they would require anything more than that, because they have also filed an exhaustive reply before the tribunal.
So we can keep it in the first week of July. On any day.
Or if my lords are putting it in June, even the courts are.
June last week.
My lords will put it in the last week of June.
Very good. So 28th June.
Yes, ma'am.
It is complete. Then counsel, senior counsel for the petitioner, Mr. A.K. Behra, submits that the surviving defect number 2 may be ignored as it is formal in nature. In the IA, perhaps they generally do not write this Article 226.
The 227 is generally not right. It is right.
It is accordingly ignored.
That's right. That's right.
Stop. Interlocutory application, he submits that interlocutory application number 3035 of 22 has been filed for bringing on record certain additional documents which have a bearing upon the outcome of the petition and have been issued after the adjudication by the learned CAT. Stop. Learned counsel for the NHAI. Seeks and is allowed 4 weeks time to file counter affidavit and reply to the instant IA. 2 weeks thereafter to learn counsel for petitioner to file reply if necessary. As prayed for, this is the case on 28th June 2022.
Can indicate that it will be taken up for final hearing on that date.
Oh, you see, whatever is there is ready for final hearing. It is complete.
Thank you.
Orders. Item number 5, first appeal number 250 of 2019. Mr. Indrajit Sinha for the appellant. Mr. Shishir Suman for the respondent.
In the present case, I state that the direction will be passed that both the parties appear in the next day for so that the compromise may take place lodging because as we have been instructed by the client, he is facing the financial constraint and hence is not able to abide by the settlement terms of the settlement lordship. The lordship I pray that after summer vacation on any virtual date, both the parties be called before the lordship and they must be asked the lordship.
Is there any proposed term of settlement?
Pardon?
Is there any proposed term of settlement?
Lordship, this is the
Mediation post installments with reschedule because of COVID. So, what is the balance remaining? 5.8. So, after 5 lakhs, nothing has been paid.
6.2 lakhs has been paid to the opposite party. And thereafter, total amount was 12 lakhs, 5.8 lakhs are still to be.
So, that was to be paid by 30th April.
Yes, after so many extensions, that final date was 30th of April.
So, your request is for extension to pay the amount or for?
Yes, lordship, I'm just praying that both the parties will be called lordship so that they might be answerable to the lordship. And as per the instruction of the client is facing some financial constraints. So, for a time may be given lordship because after summer vacation, might be able to pay the amount lordship.
You see, the term for repayment, payment and the installment date has expired. So, further extension could be granted on a formal request through an interlocutory application in which the respondent may also reply or concede to or accede to. You understand? You have not filed any formal IA for extension, giving the reason why you could not pay. It's a breach of undertaking. No? You file an IA, formal IA. Where is your appellant? He is from Jharkhand or some other place. Tell him to file an IA with supporting reasons why to extend, and she will take instructions and then we'll keep. You see, that we can understand, but he has also paid almost more than half of the amount. Total amount was how much?
5.8 has been 6.2 has been paid for that.
5.80 is still.
5.8 is
So we may not as well reschedule it, except that if he is willing to pay by a particular date, we may allow him to pay by that date. Otherwise, without court's indulgence, that payment would not be proper or acceptable. You make a file an IA. Give the reasons why you have not been able to pay. Give a copy to her. We'll keep it after summer vacation. Meanwhile, try and pay the balance amount. What's your good name? You are with?
Immediate.
Okay. So you had prepared lot of written notes in that 1st April, no? Section 24. You have seen that judgment now?
Yes, Lord. I saw it on Friday, Lord. But I was
Oh. It has come on the website.
yes. Came on Friday.
I missed giving your name also in that.
But my name is there. It has been mentioned in the appearance.
Oh, acha, it's there, yes. Then it's okay. You were with Mr. Indrajit Sinha. Ms. Anjali Sinha, the counsel for the appellant, submits that because of financial constraints, the last installment of rupees 5.80 lakhs could not be paid in terms of the order dated 3rd January 2022 6th April 2022 when the schedule of payment was modified. So she seeks to file an IA explaining the reasons with an undertaking as regards payment of the balance amount by a particular date. Stop. Let such interlocutory application be filed within this week with copy to the other side. Then counsel for the respondent may seek instruction in the meantime on the IA. The matter be listed on 14th June.
Item 6, WPS number 2100/2020. Mr. Jitendra Tripathi.
Take fresh steps because addressee doesn't reside at the given address.
The agency has popped up
No, is he in service or out of service?
He's in service.
Then you can serve through his superior.
But like this interlocutory application, this notice has been issued on it. Because
Contempt matter.
contempt matter, yes.
You take time there unless the other side is properly noticed. He must be in the jurisdiction of Jharkhand itself.
We have advised either because his contempt application is there. Aware of it, the notices has been issued.
His place of residence is in South Office Pada.
Years ago, measured the tribunal, the contempt, after we moved this application, last phase of the matter was listed. We advised that we took time.
When is the next date before tribunal?
I am just.
What is the service report? नहीं अपने जगह पर नहीं गया।
Addressee doesn't reside at the.
तो ऑफिशियल जैसा कि मलॉट ने कहा कि ऑफिशियल एड्रेस पर क्यों नहीं? Official job is in service.
Contempt of this is the address that has been given by you.
No, he is your employee.
Yes, yes.
So your immediate this postmaster general should be knowing.
He is still in service.
So we give you opportunity to serve it through two modes. One through his departmental head
Yes, yes.
and one through his counsel appearing in the learned seat. That will serve you. The endorsement on the speed post and registered cover shows that the postal peon shows that addressee doesn't reside at the given address. Stop. Notice was returned unserved. Stop. Learned counsel for the petitioner, learned ASGI appearing for the petitioner submits that there is a threat of contempt looming over their head since the applicant is pursuing CCPA number 051/008/84 of 2019. This is from your IA itself. Stop. Then counsel for the petitioner, and ASGI is given liberty to effect service of notice on the applicant/private respondent through his departmental head as is reportedly in service, and also through the learned counsel representing him in CCPA number so and so before learned CAT Patna bench, circuit bench at Ranchi. Contempt is at Ranchi only. Stop. Requisites for that purpose be filed by Wednesday. Office to issue draft of notice on the office of learned ASGI by Friday after effecting 13th May 2022. After effecting service of notice, a supplementary affidavit be filed in proof thereof in the first week of after reopening of summer vacation 2022. Matter will be listed in the week thereafter.
Item 7, WPT number 1953 of 2021, along with item number 8 to 30.
So, whatever is in the pleadings is sufficient, or you would be giving some notes also?
We have already given some judgment, just prepare a written submission.
Most of your case has already been captured in this order.
Yes, detailed order.
13th June. June, there are a batch of matters, WPT.
14.
You can keep it.
Maybe even on 9th June.
No, not just after vacation, because Thursday. You would have kept it on Wednesday, but not sure whether it's a virtual day or not. Otherwise, in case it spills over, you could have continued on Thursday. Learned AG2, all of them are in here. The virtual day, it was argued on a physical day, this one.
We come physically only.
He prefers to be. Then
14
since 13th has a huge batch of cases, so it's not safe to keep it on the next day. There are a few other matters already listed. 21st we can see. 21st June.
20th Monday will be.
Monday your Bhilai engineering is there only. 20th at Bhilai is there, but that can be over. You can keep it on Monday, 20th June. Yeah, order कुछ लिखा है? ठीक है. Then counsel for the petitioner, Mr. Sumit Garodia, submits that in terms of the interim order dated 11th April 2022, the draft or what?
Yes, draft.
The draft of rupees 17 crores has been deposited before the through challan,
It's through deposit challan before the registrar.
through deposit challan before the learned registrar general on 20th April 2022. Stop. Then counsel for the petitioner submits that since learned senior counsel Mrs. Kavin Gulati is not well today, he could not appear to address the court. He prays for an adjournment. He prays that the matter may be listed on any date as per the convenience of the court after summer vacation. Stop. As prayed for by learned counsel for the petitioner, with consent of the state council, the matter is posted on 20th June 2022. Matters are posted. Take me a minute.
फाइल करने के समय का स्टेशन भी ये
वो फाइल में से
For press filing admission, item 14 WPT number 2972 of 2021. Ms. Amrita Sinha for the petitioner. Mr. Satish Kumar for the respondent.
counter affidavit has been filed on their own.
Yes, sir. Counter has been filed for the coming for the first time.
So why don't you go in appeal?
That's what we are going to have saying that the show for the entire procedure which has been initiated, that was on the basis ex parte order. I have said that.
Is the order sheet on record? Order sheet on record? Or only adjudication order is there, or only DRC 07 is there?
So your adjudication order is also there. However, my entire thing was show cause is also there. That is also under challenge. That was not taken into consideration, and no opportunity of hearing at all was given at the time of passing. Instead of the fact that I had
No, so order sheet would be necessary, na? They have refuted their your stand in para 4 of their counter.
the entire order sheet is not there.
Bring it on record. All these cases hinge upon actual proof whether natural justice was followed or not. You could have also annexed it to your. You don't annex any document to your counter affidavit. What is an extra? It was on the basis of some inspection.
Yes, investigation being report, it was on the basis of that. In spite of the fact that I have duly paid my tax, the supplier has not paid the tax, and thereupon in fact, he has also paid the tax. He has deposited the GSTR 1, had duly filed GSTR 3B, but the only fact that his registration was cancelled later on, that is on
Which-
27/6/2019, and on that basis, the respondent department is saying that you have entered into a transaction with a non-existing dealer. I have also annexed that
That
particular.
Ma Kali.
Yes, Your Worship. And
And
That's
any proceeding against Ma Kali?
yes, Your Worship, they have initiated a proceeding against
That
Mahakali.
that Ma Kali has come before this court.
No. As per my knowledge,
You have not implemented him also.
I have not repeated.
We bring the order sheet on record. Counter affidavit has been filed. Stop. Yeah, ऐसे लिखिए. Petitioner seeks to assail the show cause notice dated 30th June 2020, issued under Section 73(1), read with Rule 142(1) of the GST Act, JGST. And also the order dated 15th September 2020, passed under Section 73(9) of the Act, alleging that not only the order is ex parte, without giving any proper opportunity to the petitioner to reply, to defend itself, but the show cause notice was also prejudged. Same language.
Same language, Your Worship. At the end, also they have written that they क्यों ना किया जाए, but the entire code.
Stop. And counsel, our learned counsel for the petitioner undertakes to bring on record the entire order sheet of the assessment proceedings. Staff learned counsel for the on record and counsel for the respondent shall also bring on record the true copy of the proceedings right from the stage of inspection or no inspection, only intelligence
Inspection was not there.
proceedings on record.
Merely on the report of investigation basis.
3 weeks time is allowed. Matter will be listed after summer vacation.
Item 15. WPT number 1406 of 2020.
In fact, this was going to happen, bound to happen. This litigation would have been the first litigation which is laid before your lordships. Where a bona fide purchaser has paid all taxes on purchases made in the year 2019. The insolvency proceedings against the seller have been initiated on March 2019. The respondents sleep over it, don't invoke the provisions of Section 122 of the CGST Act. They don't recover against him.
Let it go before other bench. Let the matter be placed before a bench of which one of us, Suresh Kumar Singh, is not a member.
One more matter.
Connected.
Yes. If we come under 20 days Thursday,
Yes.
For admission, item number 18, WPT number 4425 of 2017, Mr. Ranjit Sinha.
So the whole dispute now revolves upon the appellate order passed in respect of two other assessment years.
Two other assessment of for 2 different years. Different.
Same issue, sale price.
In that, they have accepted our condition.
Sale price,
Sale price.
not on the basis of IBM price.
No, yes. One issue and second issue is I for IA. Certain document is not available in public domain. By which definition of two LXA was inserted.
That amendment came.
Amendment came.
10th October 2009.
9. So if not.
So today what can be done? They will have to respond to the prayer because that writ petition was not entertained to give you an opportunity for appeal. Now you have come against the assessment order or appellate order? Both.
Both.
So then the question has to be decided here only. No, but not. Achha, you have lost before the tribunal also.
I think
tax commercial डिपार्टमेंट के क्या किया वो आईबीएम रॉयल्टी पे करने के लिए उसका साइकोनोरम रेट फिक्स कर रहे हैं उसी पे या पेनल्टी लग गया तो ट्रिब्यूनल का खर्च है बाकी लोग 2010 11 और 12 का इसलिए अगर पिटीशन बनाया तो में इसको शेयर में आईबीएम उसका कि ये जंप जो है ये अलग ट्रांजेक्शन हम रेटिंग देते हैं तो जो एक्चुअल रेट है मेरा कम होगा तो कम हो जाता है वो दोनों को देखिए तो मेरे सब पहले पहले उसी ग्राउंड पे उसी कलर में हो गया हाँ फिर अगेन इस पर क्वेश्चन
You file your reply to this IA and that amendment. What does that amendment say?
IA in IA two LXA was effective from the date of notification. Date of notification is 7th May 2011. Before that, assessment order and revision order has been passed.
No, the amendment to Rule 64D of the MCR is to what effect? क्या बोलता है ये amendment?
That is for purpose of completion of royalty notice.
So
My understanding is that is a different issue for the only purpose of completion of royalty. That will not be intermingled with JVAT.
no, that we understand. That's your main plank.
Yes.
But how does this amendment makes a difference to the present position?
Amendment so far.
The amendment of 2009 December, how does it make a difference to the assessment proceedings? नहीं, आपने तो ये MCR का amendment लगाया है ना, मिनरल कंसेशन रूल्स का amendment लगाया है.
What is the process of completion of
Okay, very well.
In IM, we have last year of IM.
So those two documents are only to demonstrate as to how the ad valorem is calculated.
Yes. In para 16, I have paid for 3 documents, but now I am facing for only 2 documents A and B.
Very well, then you file reply. Then counsel for the petitioner, Mr. Dubey. Vijay Dubey submits that the same issue arose in respect of assessment years 2010-11 and 2011-12, in which, upon being relegated to the appellate remedy by this court earlier in WPT number 1686 of 2013 and 1687 of 2013, annexure 6, the appellate authority has decided in favor of the petitioner. Stop. The computation of sale price on the basis of ad valorem price fixed by the IBM has not been accepted. Stop. The petitioner has lost up to the learned Commercial Taxes Tribunal in the present matter relating to assessment year 2009-10 on the same issue. Stop. However, in view of the stand action, seven and eight. 7 and 8. Stop. Interlocutory application has therefore been filed bearing number 4425 for leave to produce these documents for proper adjudication of the dispute. That those documents are in your rejoinder. Second supplementary. Counter affidavit has been filed earlier by the respondents. Stop. However, when counsel for the state is allowed 4 weeks' time to file reply to the second supplementary affidavit dated 30th January 2021 and IA number 555 of 21. IA ka number 555. Stop. Matter be listed after 4 weeks.
Item 19, PA number 9 of 2019, Ms. Amrita Sinha.
You have not filed that supplementary.
It is ready, Your Lordship, but the person authorized to sign and swear that affidavit is having some personal difficulty is not able to come down to that, Your Lordship. And since last 1 week, I have chased
File
him,
the
Lordship, just one more indulgence I am saying there to file this. It is ready, Your Lordship, just in order to get it affidavit.
other side is appearing.
Yes, Your Lordship, Manish Mishra sir.
When counsel for the appellant revenue is allowed 1 week time, further time to file supplementary affidavit incorporating additional substantial questions of law. Stop. Matter be listed after summarization.
Substantial purpose.
Income tax. Very interesting.
Item 20, year number 25 of 2019, along with item number 21 and 22, Mr. Rahul Lamar for the opinion.
सब्सटेंशियल होता है तो कुछ रिस्पोंडेंट नहीं रहता.
Item 20 to
So, whether that provision for warranty expenses was rightly added as total income or additional income or not, that is the main dispute. According to you, it was an unascertained.
Uncertain, and there was no specific or a scientific basis on which they calculated the amount of 0.5%. This issue is settled by the judgment of the honorable. Only the facts have to be seen. Now the problem is because we learned IT without any basis of facts, underlying
That
facts.
Earth Movers case.
More than Bharat Earth Movers, Roton concourse in their argument is important. This has been relied by the IT also. I am also relying on this. So this is 2009 volume 13 SCC 283. That's in the list.
2009 volume.
13 SCC 283. In fact, this is subsequent to Bharat Earth Movers. So that is why this is more accurate. There are three broader conditions which the Supreme Court has laid down.
So if it is not a contingent liability, then it is deductible.
It needs to be ascertained. The liability may be incurred in future, but today it should be ascertained that this liability will come in.
So they deducted it without being proper ascertained.
Yes, without any assessment, without anything, they just fixed a random figure of 0.5% of their total sales, and they kept on keeping it in provision. Now, it is through their own statement, it is shown that this 0.5% was not right, because every year they had warranties which were never exercised or invoked. So they had to add back the leftover warranties to their income. That is what exactly the Supreme Court says in this judgment.
They had to add back.
Because what they used to do is, in fact, today now here in 2020, they had deducted 40 lakhs towards provision. Now it happens that in the next year, their liability which they incur is only 25 lakhs. So 15 lakhs is not incurred. So this 15 lakhs is reversed. And this was happening continuously every year.
Reversed in the next return.
In the next year.
That itself amounts to a
Yes, this
admission.
shows that their assessment was bad. It was not based on a scientific assessment.
Just explain it a bit more for the benefit of brother also.
What happens generally in business, a businessman has to keep a provision that these liabilities may come in the future. So the Income Tax Act provides that this can be allowed as expenditure, provided the provisioning which you are making for future liabilities is based on some scientific basis.
No, what exactly is the provision for warranty expenses? That you need to explain.
Well, what happens, the assessee, in this case the respondent, is making heavy machines. Now when these machines are sold to their ultimate consumers, the ultimate consumers want warranty. Like when we purchase air conditioner, the company gives us 1 year warranty. So they also give warranty. Now, in case if there is any fault in the machinery, the customer can claim and they have to either replace or repair whatever the goods are. So towards those expenses, they keep this provision. That is allowed. Keeping provisioning is allowed, but based on condition. One of the conditions is that it has to be based on a scientific assessment.
Let us see section 37. IT type of
The judgment of the honorable is detailed. Broad judgment.
provision for warranty figures in which clause of section 40?
Well, this is provisioning for expenses in the future. These expenses are generally allowed in section 37. These are allowable in 37. These subsection I am just.
Explanation says expenditure incurred. It does not say anticipatory.
Yes.
Those in anticipation of the expenditure incurred. So warranty, how can you expend? You have not spent anything.
But that is what matters. But the Honorable Supreme Court had interfered, and Honorable Supreme Court since last 3 judgments prior to this have said that if it is ascertained, then you can claim. So but this is the interference of the Honorable. So that is why we are relying on the judgment.
What is the relevant part of this judgment of the Honorable Supreme Court?
So my lord is absolutely right because 37 does not say about anticipated expenses. Section 37 is something which says you have already incurred.
So, what is the relevant paragraph of this judgment?
This is 2009 volume 13 SCC
Yes.
283 and relying on
Paras 39 and 43.
at para 22 the finding starts.
What method of accounting do they claim to follow?
So that is the whole issue. The learned IT team should have brought all these facts that what was their accounting basis, what was exactly the scientific basis on which they were accounting. Because what the learned IT team says is that because they have been following 0.5% as consistent every year, therefore it's a scientific method, therefore it is being allowed.
In this particular case also that plea was taken.
In fact, the ITF has decided in their favor relying on this judgment, says that the facts are identical, whereas the facts are not identical.
What is the provision? This is the question which needs to be answered. Para 22.
Para 22, there are 3 conditions in Honorable Supreme Court has made for claiming. The last condition is most important, that there has to be a reliable estimate. Now, this reliable estimate has to be on some scientific basis, and it has to be ascertained, that is, and a detailed assessment has to be there. So that is what it is provided in this judgment at para 31.
Oh, so here also being
They are
reversed.
also being reversed.
Such estimates need reassessment every year.
So it cannot be consistent. In fact, this is contrary to what the current ITS says. The current ITS says because they are maintaining 0.5% as consistent every year, therefore it is scientific. It cannot be. They have to undergo assessment every year.
Where are the substantial questions of law?
My apologies, it's a substantial question of law, not properly law. So, it's there on the page 9 of the memo of opinion.
All three appeals relate to different years.
Different years, madam, we have the tax appeal number 25 and tax appeal number 38. Madam, the issue is only with respect to provision of warranty expenses. In tax appeal 37, madam, this matter there are various other issues.
So then what we do is to keep it on Thursday. You give us
I will redraft.
redraft the substantial question of law in these two identical appeals and in the third one. Very well.
Much of it.
Post these cases on 12th, 12th May 2022. As per program. 11th also you can. 11th. उनका पे बोल दीजिएगा हमको दिखा देगा।
Item 26, WPT number 3560 of 2020, Mr. Nitin Kumar Prasad.
Only I said for
We have filed a written submission as well as the live motion.
This is again a case of no show cause notice.
No show cause notice to lordship. In this case, an inspection was carried under section 67 without recording grievance to be. We have challenged that for the lordship as well as on the basis of jurisdiction.
Order sheet is also on record.
Yes, lordship is on record.
You were issued DRC 01A only or
No, only class 01 and directly class 0.
DRC 07?
Yes, DRC 07 or order. But no detailed show cause notice, no detailed order, nothing.
20, Mr. Mohammad Zaid Ahmed for the petition.
So this was the matter in which you allowed time to file supplementary affidavit.
On that case, the person was fine. So online letter was filed within 10 hours.
Now, Mr. Mittal was also asked, Salona Mittal was asked to seek instruction.
Because we have it's more time to file.
And what document have you brought on record to show technical glitches?
That is also after page 5 of my supplementary affidavit.
Page?
Page 5 also. Page 5, in which we have applied for the searching from computer to regular. That was during the instruction, all the 13/7/2018. Apart from that also, there is a screenshot of my lordship, in which the date is shown up in last line, 13/7/2018. And after the page, seven of the cell has been accepted after that he has made the complaint, and accordingly, by the portal, ticket number 1, 2 tickets were issued. That is page 7. And it also detailed me, which we have sent to the confirmed response. Apart from that, also, my main petition is said also, there is the admission of their part. That is annexed 0 also.
No, you have argued on that day. Let them file.
Firstly, for the material is only covered by the contract, honorable secret controls. For the we are making certain judgments.
Cost जमा किए थे आप?
Yes, sir, that is not so. Then, my commitment on that.
And is allowed further 3 weeks time to file counter affidavit in terms of the order dated 12th April 2022. Stop. List it.
One judgment. This is directly covered.
पहले आने तो दीजिए. The technical glitch का please.
They just state one thing, this CGST is not being treated as a party, but the copy has been served first. That is treated as a
He is
party.
taking a plea of technical glitch.
Yes, sir.
Ultimately, GSTN will have to answer whether there was a technical glitch or not. So we can allow him, if now that he has paid 10,000 cost for more than 1 year, 2 year, he had not filed this supplementary affidavit to give some documents in proof of that.
Not sure. Very interesting. Some documents were provided to me.
ठीक है, तो अब we can allow GSTN to be added as party. GST has got nothing to do.
No, they served as a copy and we are that is what they
Let GST network through so and so give the description of the name of GSTN.
Yes, sir.
Be added as a party respondent in the writ petition for which necessary addition be carried out by learned counsel for the petitioner in the array of parties during course of the day. As respondent number 5. Stop. Mrs. Ranjana Mukherjee, learned counsel AC to Mr. P.S. Pati, accepts notice for the newly added respondent. Copy of the pleadings have already been supplied to her.
Yes, sir.
Stop. She may also seek instruction in 3 weeks' time. The matter will be listed after 5 weeks. We have 4 weeks to be. Give that copy of judgment to the court master so that we can go through. At least 2 copies. Yes, next.
Item 30, TA number 8 of 2021, along with item number 31, Ms. Samita Sinha.
Anyone appearing?
I check the status for
Who appears for this? There, Tata.
TRF for TRF for TRF there is no impact.
So Mr. Salona Mittal or Mr. Garodia, they appear for the
TRF for
Tata.
Tata Steel. Tata Steel service Garudia sir is also there for Tata Motor. But for TRF,
When is the service of notice?
yes, sir. The notice was filed on 9/3, order is dated 18/2022, notice was filed on 9/3/2022. And by mail also it was sent on 10/3/2022. I have filed a supplementary affidavit to that extent.
Service of notice is complete as per the office note. Since receipt of endorsement containing receipt of service on this acknowledgement due and track consignment under registered cover and track consignment report of speed post shows item delivered. Stop. Supplementary affidavit has been filed with the appellant showing service of notice through email in terms of the order dated 8th March 2022. Stop. Respondent has not entered appearance through Wakalatnama. Should we wait for them or should we admit and then
So what indulgence we give it?
one more indulgence is granted to the respondents to enter appearance? Matter be listed after summer vacation 2022.
Both the matters are same.
Item 32, TA number 17 of 2021, Mr. Amit Kumar for the appellant. Mr. Salona Mittal. for the respondent.
That supplementary affidavit has not been filed.
post that version. So, the real case to go from a lower post version. But not to them. Highest version on the next page, we can study for the procedure, documents to get the last email.
Then counsel for the appellant, Mr. Amit Kumar, submits that the relevant documents placed before the supplementary affidavit could not be filed in terms of the order dated 15th March 2022, as the documents are in the process of being obtained from Learned Sestak, Kolkata. So therefore, time has been prayed for 3 weeks' time, and no more is allowed for that ground. Matter will be listed after 4 weeks.
Item 49, WPT number 493 of 2022, Mr. Ashish Kumar for the petition.
This is hard copy that need cannot order from counter very fast so that on the next day filing hearing.
Your appeal has been dismissed on the ground of limitation. So they have shown that the order in original was delivered to you and in 2018 or 17 order? 18. 17 December 2018 OIU. And you filed the appeal in 2021 perhaps. After this court gave you, relegated you to the appellate remedy. So how do they overcome the appeal? 2 months plus 3 months, isn't it? 60 plus 90 days. So now, how can that order be said to be wrong? ये बट वो सुओ मोटो केस का बेनिफिट नहीं लिए हैं लगता है. लिए हैं सुप्रीम कोर्ट का जो सुओ मोटो में लिमिटेशन एक्सटेंड का है वो आप इसमें लिए हैं अपने प्लीडिंग में. नेचुरल जस्टिस नहीं भाई. अमृता जी आप इनको जरा बताइए. नहीं तो इनका पूरा पेनल्टी पूरा. यही है कि
And this issue will, against the law, we should cite a lawsuit that cannot be condoned the day after that. It should be considered decided, yeah, we high court से there.
हाँ, लेकिन इनका ऑर्डर ही बहुत पुराना है ना, 17/12/18 का ऑर्डर। तो उसके बाद ये हाईकोर्ट आया, हाईकोर्ट में कहा गया कि आप अपीलेट में जाइए, प्लीज उनसे कुछ मदद ले लीजिए। Learned counsel for the petitioner undertakes to serve copy of the pleadings upon learned counsel for the CGST stuff. ये क्या है? सर्विस टैक्स का मैटर है। CGST, Mr. Amit Kumar, who appears for the same department, CGST, then counsel for Mr. Amit Kumar. Stop. By day after tomorrow?
Yes,
The matter will be listed after reopening, summer vacation 22. Then counsel for the CGST may in the meantime also file counter evidence. चलिए, आप समझ लीजिए जो ग्राउंड है।
खाली करवा दीजिएगा, सबसे सफाई करवा